All right, so welcome everyone to the speaker program of the U.S. Asia Law Institute at NYU School of Law. I'm Catherine Wilhelm, Executive Director. Today's program is the latest in a series of occasional talks that we have been hosting called Taiwan Legal, and we are exploring and explaining the status of Taiwan according to the law of various jurisdictions, both domestic and international law. You can find the recordings of our previous sessions on our website. So here to moderate the session and joining us on Zoom is Professor Jerry Cohen, who is the founder and faculty director emeritus of the U.S. Asia Law Institute. Let me first just say how the session is going to proceed. First, Jerry is going to introduce our speaker, Professor Yu-Jie Chen, and he'll say a few words to get us started, and then Professor Chen will make some opening remarks, followed by a brief conversation with Professor Cohen, and then around 1:15 we'll start taking questions from the audience, those of you in the room as well as those who are online. So with that, Jerry, the mic is yours.
Thank you, Catherine. We're delighted to have Yu-Jie Chen back with us. She spent many years at NYU getting her doctoral degree working with the U.S. Asia Law Institute and has just been promoted to associate professor with tenure at Taiwan's leading academic institution. We're talking about Taiwan's self-perception. What does Taiwan law say about Taiwan? Nothing could be more important. We're all worried about relations between the United States and other countries, especially China. And nothing is more likely to invoke the displeasure of China and the risk of war than if Taiwan says the wrong thing. And what we need to know is, what has Taiwan's official stance been? What is Taiwan? And why should we worry about going to war over it? Ukraine has made Taiwan perhaps the most important flashpoint in the world. So, Yu-Jie, we're delighted you're here, and after you talk for a while, we're going to have a very good discussion.
Thank you, Jerry. I want to thank Jerry and thank Catherine for this opportunity to present this very important subject. I think Jerry summarized it very well. This is about how Taiwan perceives itself in legal terms. So today's topic is, what does ROC law say about Taiwan? And in today's presentation, I want to make 3 points. Okay. The first point is transformation. So I'll discuss how much the ROC Constitution of 1947 has changed to where Taiwan is today. And the changes are so significant that they amount to a complete transformation of the ROC law. So that's my first point. The ROC law is not static, and it has been transformed. The second point I want to make is Taiwanization. This is what many Taiwanese scholars refer to when they discuss the process of this transformation of the ROC law. That is to say, the ROC Constitution has been tailored to meet the circumstances of Taiwan, and Taiwan only. In this Taiwanization process, the current ROC Constitution has turned away from a China-based constitution to a Taiwan-based constitution, reflecting a Taiwan-centric approach. The third point that I want to make is discontinuity and its implications for assessing Taiwan's legal status. So I highlight my argument that there is a substantial discontinuity between the old ROC Constitution and the current ROC Constitution, to the point that the current ROC Constitution constitutional order justifies Taiwan's status as a state. Okay, let me go into my first point about transformation. First of all, as I said, the ROC law is dynamic. The current ROC constitutional order is actually very different from that of the ROC almost 80 years ago. What was the old ROC constitutional order? The ROC Constitution was first adopted in 1946 by the ROC National Assembly and came into effect in 1947. It was a constitutional order for ruling mainland China. How about Formosa and Pescadores? They were, in 1947, still Japanese colonies, but the ROC government anticipated that Taiwan would be returned from Japan to China in the years to come. So the ROC government also applied this constitutional order to Taiwan, which it occupied after the war ended. However, contrary to what the ROC had hoped, Taiwan's title was not transferred to the Chinese state. For this, I recommend that people, if they haven't done so, watch Professor Peter Dutton's video talk in this Taiwan Legal series, in which Professor Dutton discusses the post-war legal arrangement that intentionally left Taiwan's status unsettled. So coming back to the ROC Constitution, the 1947 Constitution was short-lived in mainland China because in 1949 the PRC was established and the ROC government retreated to Taiwan. At this point, the ROC Constitution ceased to be practiced in mainland China, but continued to be applied in Taiwan. However, it was a constitution impossible to practice in Taiwan because the state structure provided for in the 1947 ROC Constitution was for the whole of China. So, for example, since 1949, it was impossible for the ROC government to hold elections in mainland China for its National Assembly as representatives in accordance with the ROC Constitution. Nevertheless, Chiang Kai-shek wanted to maintain the illusion that his government still ruled mainland China, and therefore the ROC government suspended all the elections in Taiwan to allow those representatives elected in the mainland in 1947 to continue their term in Taiwan for the next 4 decades. This was intended to maintain the false appearance that the ROC government still represented mainland China. I think it's a good example of what Holmes Welch called the Chinese art of make-believe. As these National Assembly delegates served from 1947 to 1991, they were in Taiwan called 10,000-year delegates. So let us turn to the situation of the current ROC constitutional order. So fast forward to 1991. By the time of Taiwan's democratization, Taiwanese society had long realized that the 1947 ROC Constitution was unrealistic and unsustainable for Taiwan. It needed to be changed to suit the reality of Taiwan, and democratization enabled these necessary changes to happen. So this is what prompted the first constitutional amendment in 1991. What did the constitutional amendment achieve? First of all, it removed the 10,000-year parliament that I just described. This parliament pretended to represent mainland China, but in reality, it was not sustained. So instead, once these delegates were removed, elections began to be held in Taiwan, and they were only limited to Taiwan's population. The second achievement was that the constitutional amendment, we refer to them as additional articles. The additional articles authorized a special law to deal with cross-strait relations. This is the 1992 Cross-Strait Relations Act. What did it do? The law separates Taiwan from what it calls the mainland area, which the government recognized as out of the ROC's jurisdiction. So under this law, the PRC citizens are labeled as people of the mainland area. They're not foreigners per se, but they're also not ROC citizens, and therefore they are excluded from Taiwan's political community. So for example, they cannot vote, and they cannot claim the political rights enjoyed by Taiwanese as a political community. The entry and exit of mainland Chinese to and from Taiwan is heavily regulated, and they certainly cannot assert the right to return to their country when entering Taiwan, which is a fundamental human right. They must also undergo a process similar to naturalization in order to obtain Taiwan citizen status. So the similarities between the PRC citizens and foreigners in Taiwan's legal system are numerous. Essentially, PRC citizens, although they have the unique label of people of the mainland area, they are regarded as foreigners in every sense except name in Taiwan's legal system. Another thing is territory. This is a more tricky question. The 1991 Constitutional Amendment and the Cross-Strait Relations Act label the mainland area as the territory of the ROC. But looking closer, this is another example of the art of make-believe that I just mentioned. Because despite this label, the mainland area is regarded as a foreign land in practice. The simple example is when Taiwanese travel to the PRC, they're essentially leaving the country to enter another country. Third, the 1991 Constitutional Amendment also allow the PRC government to be branded no longer as a rebellious group, but as a equal political entity. So starting from the 1990s, the PRC government has been described by the ROC government as a political entity, which essentially is considered legitimately ruling mainland China from Taiwan's perspective. So, as I have just described, there's a big difference between the old ROC Constitutional Order and the new ROC Constitutional Order. For the purpose of our discussion, I refer to the 1947 ROC Constitution as the historical ROC Constitutional Order in order to distinguish it from the current ROC Constitutional Order after 1991. Having said that, despite the transformation, things are not always clear-cut. There are still remnants of the historical ROC Constitution that perhaps we can address later in the Q&A. But for now, I want to make the point that this transformation represents a process of what is often called Taiwanization of the ROC. So this brings me to my second point, that the current ROC Constitutional Order is a product of Taiwanization. What does Taiwanization mean? For those interested, my colleagues at Academia Sinica's Law Institute, Su Yantu and Lin Jianzhi, have written about the Taiwanization of the ROC Constitution. For today's discussion, I think it's useful to compare the following aspects of the ROC, the historical ROC Constitution and the current ROC Constitution to highlight the distinctions between the two. So as you can see from the chart, first one, sovereign powers. The historical ROC claimed sovereign powers over mainland China, but the current ROC claims sovereign power only Taiwan, specifically Taiwan, Penghu, Jinmen, Mazu. It doesn't extend the sovereign claim to the mainland area. The political community are also very different between these two constitutional orders. The historical ROC Constitution included mainland China, represented by the 10,000-year parliament that we just mentioned. This is without any regard to the desires of the Taiwanese people for elections. In contrast, the current ROC Constitution regards its political community as Taiwanese and Taiwanese only. The third point is international identity. There's also a major difference. The historical ROC claimed to represent the mainland Chinese as the government of the Chinese state. In contrast, according to the current ROC constitutional order, since the 1990s, Taiwan's government has consistently claimed in its foreign relationship to represent the Taiwanese and Taiwanese only, not including mainland Chinese, and not seeking to represent the state of China. So what is the implication of this Taiwanization process for cross-strait relations? So, the historical ROC government regarded the CCP as a rebellious group in the context of the Chinese War. This was because the Chiang Kai-shek and his heir Chiang Jing-kuo clung to the idea that the ROC was the sole legitimate representative of the Chinese state, and they could not permit the PRC government to assert its claim to represent China. But in contrast, the current ROC government has viewed the PRC government as an equal political entity since the 1990s. As I said, this means that the PRC government is seen as legitimately ruling China rather than a rebellious group. So to reflect this new framing of cross-strait relations since democratization and since Taiwan's constitutional amendments, various political leaders in Taiwan have developed distinct political formulas to try to best characterize cross-strait relations. So Li Denghui famously used the term special state-to-state relations to refer to the relations across the Taiwan Strait. The idea was that the ROC on Taiwan is already a sovereign state, despite its special relations with mainland China. So according to Li Denghui, because cross-strait relations were defined as special to state relations since 1991, quote, there's really no need for Taiwan to declare independence again, unquote. Chen Shui-bian, the first DPP president, used the formulation of one country on each side. This also reflected that Taiwan is a sovereign state, distinct from the Chinese state. And the similar idea has been expressed by the following DPP presidents, including Tsai Ing-wen and the incumbent Lai Ching-te, both asserting that the ROC and the PRC are not subordinate to each other. These formulas reflect the Taiwanization process of the ROC. This is also why these leaders often combine Taiwan with the ROC to refer to our country. They use phrases such as ROC on Taiwan, ROC in Taiwan, ROC parenthesis Taiwan, or simply ROC Taiwan. The exception to this Taiwanization was former President Ma Ying-jeou. Ma stands closely aligned with the historical ROC's position that Taiwan is part of China, but he asserted that that China refers to the Republic of China, not the People's Republic of China. So this viewpoint is known as the one China respective interpretations formula. However, this pro-unification position is a minority position in Taiwan. As of 2024, only 1.1% of Taiwanese favor unification as soon as possible. And the support for maintaining the status quo while moving towards unification only reached 5.8%. The majority of Taiwanese prefer either to maintain the status quo, which suggests that Taiwan's separation from China, or to advocate for independence. Now we enter the third point, discontinuity. Why are we discussing all of this today? Why does ROC law matter? It matters when we evaluate Taiwan's legal status. So this is the implication. When international scholars examine Taiwan's status, they often overlook the transformation and Taiwanization process we discussed earlier. For instance, the late ICJ Judge James Crawford is frequently cited to deny Taiwan statehood. Crawford concluded that Taiwan is not a state because the government in Taiwan continues to characterize itself as the Republic of China and to stress its continuity while increasingly practicing discontinuity. It is still the case, Crawford concluded, that Taiwan has not unequivocally declared its independence from China. In other words, Taiwan's statehood is often questioned in legal terms, not because Taiwan fails to meet the statehood criteria. Many international scholars agree that Taiwan meets the statehood requirement, including a permanent population, a defined territory, a government, and the capacity to enter into relations with other states. But they argue, based on Crawford's influential scholarship, that the problem for Taiwan is really that Taiwan continues to identify itself as the ROC, which suggests continuity with the Chinese state and consequently blurs Taiwan's claim to independence. But I believe this perspective oversimplifies the issue by placing too much emphasis on formalities while overlooking the substance. That is, the real political and legal changes in Taiwan. As I have discussed, Taiwan's constitutional amendments, as well as Taiwan's constitutional practice since 1991, point to a discontinuity between the historical ROC and the current ROC Taiwan. So, how is this discontinuity demonstrated? There are several aspects. First of all, in population and territory, the population envisioned by the historical ROC Constitution has been discontinued, as we have already discussed. Second, the historical ROC's territorial claim over mainland China was in effect discontinued as well. Third, the historical ROC government that sought to represent mainland China and mainland Chinese people has also been discontinued in today's Taiwan. And the historical ROC's claim to be the only legitimate government of Taiwan on the international stage has also been discontinued. So today's Taiwan no longer seeks to represent China. So let me close by emphasizing that Taiwan status is not just an academic issue. It has real-world consequences. So just in the past few days, China launched yet another large-scale military exercise encircling Taiwan, the sixth one since 2022. In reporting China's exercise, the international media continue to use phrases like, quote, Taiwan is considered a breakaway province from China's point of view, unquote. So how about Taiwan's point of view? Shouldn't Taiwan's perspective be part of the conversation when discussing Taiwan? If we only limit the discussion to China's unilateral claim that Taiwan is part of China and should be treated as an internal affair of China's, then how can we talk meaningfully about keeping Taiwan safe? So those are the questions that I hope we can keep in mind as we move into the Q&A session. Thank you.
Well, we just heard a remarkable introduction and summary of the situation. Implicit in this account is the fact that world peace depends on what the Chinese leaders choose to do in response to what happens in Taiwan. In other words, Taiwan has it in its grasp to involve us in a war, given Chinese policy, that any formal recognition by Taiwan of independence would be cause for war. And do we want to leave this decision up to Taiwan? And that raises the question of not only what have Taiwanese leaders offered in differing approaches, but what do third countries say? What does Japan say? After all, Japan got us into this by its seizing of Taiwan in the 19th century. And its failure to solve the problem of Taiwan belonging to China or not in the 20th. What does South Korea say? What the Philippines, all the countries around, they must have a policy. And what has their policy been vis-a-vis Taiwan? Are they of the view that Taiwan is independent? How do they treat it? Could you tell us a bit about that?
Sure. So this is the famous discussion about the difference between Beijing's One China principle and other countries' One China policy, which really need to be clarified, not only in academic discussion, but in political discussion as well. So indeed, not all of the countries agree with Beijing's One China principle. Beijing's One China principle consists of three parts. First part is there's only one China. Second part is the PRC government is the legitimate government of that China. And the third part is Taiwan is part of China. But as we know that some countries do not agree with the last position that Taiwan is part of China. And so for the United States, which Jerry is knowledgeable about, the U.S. position, interestingly, in back in 1960s, 50s, 60s, until the 70s, there was still a very strong view that Taiwan's status was undetermined, and that was done intentionally by the U.S. and other countries that signed the San Francisco Peace Treaty in 1951. But that narrative has been downplayed after the United States government established relations with the PRC government. But the U.S. government, interestingly, never sort of recognize or approve the PRC's claim that Taiwan is part of China. In the Shanghai Communique, famously, the U.S. government tried to navigate this issue by saying that it acknowledged the PRC position. It does not challenge it, but it never says that it agrees with the PRC's sovereign claim over China. Japan's position is sort of really hard to describe, but if we can think of it as a non-position. So basically, I think the thinking is that Japan has already renounced the title to Formosa and Pescadores in the San Francisco Peace Treaty, and therefore Japan is not in the position to make any more decisions about Taiwan's sovereignty. I'm oversimplifying it, but for the purpose of our discussion, Japan also does not agree with the PRC sovereign claim over Taiwan.
You advise the new Taiwan government to do when it's confronting this range of choices? Are they wise simply to follow what Madam Tsai did as the predecessor leader of the government? Or is there some innovation? Is there some new position that might put Taiwan in a better place?
It's very challenging. The question is not that Taiwanese people do not know what they want. The question really is, what would the PRC do if Taiwanese people decide to carry out what they want? If we look at the public opinion polls year after year, you see a clear trend of a rising Taiwanese identity and a more support for maintaining the status quo. The status quo is quoted because it's a very tricky word. It's not always clear what do you mean by status quo, but from Taiwanese perspective, status quo is a code word for keeping Taiwan the way it is, which is to say Taiwan is not China. Taiwan is separate from China, and Taiwan runs its own system, has a democracy. People enjoy the democratic way of life. So all this is sort of packaged into the term the status quo. Why do we need to use this sort of secret word to indicate our intention? That is because if Taiwan says we want to declare independence tomorrow, there will be missiles firing across from the Taiwan Strait. There will be consequences and there will be destruction. And that is not something. Taiwanese are very politically savvy. They understand the consequences, and so I think that is reflective from the sentiment on the ground. While a lot of people want to keep Taiwan as is, or even want to see Taiwan being recognized as a state, that is a very universal sentiment in Taiwan. The expectation that Taiwan can finally, one day, join the United Nations, be recognized as state universally. However, the reality is, for the moment, it's not possible to do that. So all this is to say that Taiwanese leaders are walking a very tight rope. There's a balance to strike between honoring Taiwanese people's desire and their hopes for Taiwan. On the other hand, Taiwan government, Taiwanese leaders also have to be alert to the Beijing's reaction and to avoid the escalation of a political conflict into a military conflict. So I believe that all the different leaders, Ma Ying-jeou excluded, they try to, in their formulas for describing Taiwan and Taiwan's relations with China, they try to reflect the process of Taiwanization, asserting Taiwan's sovereign identity while not being seen as overtly provocative. So that is why we see the formulas not always that upfront and direct and say Taiwan is a state distinct from the Chinese state. Instead, they say, Li Denghui say, Taiwan's relations with China is a special state-to-state relations, and Chen Shui-bian say it's one country on each side, and Tsai Ing-wen and Lai Qing-te say the ROC and PRC are not subordinate to each other. This is really a roundabout way to say Taiwan is a sovereign state, but really not directly saying that in order to not escalate the situation. So all that is to say, it's a hard balance, but I think the point of my presentation today is to say Taiwan, based on all these years of constitutional practice since democratization, its practice has already been sufficient to suggest its repeated claim as a sovereign state. Despite all the strange labels that we use in our constitution to refer to mainland China, to refer to people of mainland China, Taiwan's constitutional practice has reflected its claim to sovereignty.
What about Ma Ying-jeou's position? You seem to differentiate his attitude toward dealing with the mainland from the variety of other formula.
Yes, so Ma Ying-jeou was indeed very, very different in his characterization of Taiwan. So his position, as I mentioned, was really a legacy of the historical ROC constitutional order. He believed that the ROC is still the country that Taiwan is today. The ROC established in 1912 still continues in today's Taiwan. And Taiwan is part of that ROC, the big ROC, and that big ROC still claim sovereignty over mainland China. But that is, I would say, a very not only an unrealistic position, because it doesn't reflect the reality. No country in the world would seriously recognize the ROC government as the legitimate government of the state of China as of today. The second thing I would say is that position is also very dangerous for Taiwan. It's not instrumental for Taiwan security, because once, based on that position, if we admit that Taiwan is part of China, then I think the world would say that China, the Chinese state, is currently represented by the PRC government, and therefore, if Taiwan is part of China, then Taiwan is part of the PRC. That's a natural conclusion that one would draw from Ma Ying-jeou's formula. Despite whatever you say in Taiwan we still, I believe there's still supporters for the China ideology that in support of the old ROC's existence, but the reality is that the world already is way past the period of the post-war. So there's really no way to have the world recognize the ROC as China's representative. So I do think there's an embedded danger in that position for Taiwan. I hope that the KMT will see that danger and revise this position, because there has been talk within the KMT to revise the formula because it doesn't reflect the public sentiment in Taiwan, and it's not what Taiwanese people want.
What do you think is going to happen? Anything? Or are things just likely to move on the way they are?
I worry about these very dangerous military exercise and gray zone activities that China has been doing around the Taiwan Strait. It definitely sends a signal about China's intention. There are all kinds of estimates in terms of when China will invade Taiwan, etc. A prospect I don't think we can easily dismiss, but there are also other coercive measures that China can resort to other than a full-on invasion, such as blockade, cutting cables, or sending disinformation through cyber attack. All this is to say it can try to really undermine or sabotage Taiwan's function as a democratic state. And that is something I think maybe even more immediately worrying than the possibility of a full-on invasion. On the other hand, I don't think we should dismiss any possibility, because the PRC's government has always, the Chinese Communist Party leaders have always made Taiwan a part of the essential pillars for legitimacy. Obviously, this is more than a calculation of interest, and especially for Xi Jinping, the current leader, I do think he has a very strong belief, not just in the interest of China, but in the sort of for the hope of the rejuvenation of the Chinese nation, that Taiwan should be absorbed into China. I think this is more than, as I say, calculation of interest, and we have to be very vigilant.
What about the public international law argument that has been made, previously discussed, about Taiwan was part of Japan, taken by a treaty. Then Japan lost the war and returned Taiwan to China. At least it didn't indicate to what China. But isn't it obvious that Taiwan, under public international law, would be considered part of China? And therefore, the public international law claim of the Taiwan leadership is not impressive for those who go by traditional international law. Is there much of that, or people think that's something of the past or the future?
So yes, we know that there's been argument, actually, that this is the argument of the PRC, and I would say it's it's really heavily discussed, and I would refer people to Professor Peter Dutton's talk in the Taiwan Legal series earlier this semester. I think he very well summarizes why it's not the case that Taiwan's sovereign title has been returned to China. But yeah, it continue. I mean, the discussion about the Cairo Declaration and Potsdam Declaration continues to be relevant in the PRC's narrative. But I think if we give international law and the peace treaty, if we take them seriously, then it was indeed the intention of the countries that signed the peace treaty in San Francisco not to make this a settled issue, not to make Taiwan status a settled issue. So that's validated by the historical context, that's validated by the country's intention. And of course, one can say that this is really unjust that the Cairo Declaration or Potsdam Declaration were not carried out. But that was the situation after World War II that, eventually resulted in that specific legal arrangement that made Taiwan's status unsettled. The other thing I want to say is that that's not the only point of view. We know Taiwan's legal status is so contentious that there are many scholars who have their own opinion and arguments about Taiwan. One is by Professor Chen Long-Zhi, who raised the idea of what we call effective self-determination theory. That is to say, Taiwan, although its status was left undetermined after the San Francisco Peace Treaty, has effectively exercised its self-determination throughout democratization process, and therefore has asserted itself to be a state. That's another theory and argument that's being widely discussed in Taiwan and shared by many Taiwanese scholars. And so when I concluded my presentation, I mentioned the importance to have Taiwan have a seat at the table because it's Taiwan's status is in stake, that is in stake, and then I believe that the voice from within Taiwan should also be heard.
Tell me about the relationship of scholars to policymakers in Taiwan. Do scholars have a special place, or can they be ignored as theorists who don't know the facts?
So I know Catherine wants to have the session to open the floor to the audience here. So I'll conclude by saying that I believe scholars in Taiwan have our work cut out for us. We have really responsibilities to do good scholarship in order to keep Taiwan safe. And Taiwan's government is very attuned to listening to scholars, experts. It's taking it in, and it's part of the democratic process. And so, we do, as scholars, try to be active in Taiwan and internationally. So I'll have Catherine handle the session from here. Thank you, Jerry.
Thank you very much, Yu-Jie.
Great. So you were having an interesting discussion, but I can tell people here and also online are eager to raise some questions as well. So what I'll do is I'll just start making a cue. If you want to ask a question, if you're in the room, give me a signal of some kind. And then I also have some online. Sure, why don't you begin, please?
All right. Fairly recently, PRC was promoting their so-called solution of one nation, two systems that was supposed to apply to, in their view, Hong Kong, Macau, and Taiwan. Given what happened in Hong Kong recently, is there any support in Taiwan for such a solution these days, or is the Hong Kong situation and any support for such a one nation, two systems approach?
Thank you. I think one country, two systems was not very popular to begin with in Taiwan, but it became even more unpopular after China cracked down on Hong Kong in 2020 with the imposition of national security law. So you're right that the Hong Kong experience does have an impact on Taiwan. But I wouldn't say that before Hong Kong, Taiwanese were open to the idea of one country, two systems. It was already not well received. There's a lack of trust, and that lack of trust with what China would do under one country, two systems was definitely made evident in the Hong Kong experience. And so if we look at Taiwan's public opinion polls, I would recommend that people go to National Zhenji University's Election Study Center. They have two public opinion polls that have been done since 1992 and 1994. It's very consistent because they do it every 6 months. The trend is very consistent. The support for unification was very low. For example, in when the poll began in 1994, it was 4.4%, but today it's 1.1%. And so the majority of the Taiwanese favored status quo, either status quo indefinitely or status quo now but decide later, or status quo moving towards independence. These are the popular options. And you also see, as we were talking about Hong Kong, you also see the trend, the rapid rise for the support of all these options that I discussed, the rise after 2019. And that's when that's when Hong Kong protested, and that's when China cracked down on Hong Kong. So Taiwanese watch the news of Hong Kong's experience on a daily basis with horror, so they know, and this is reflected in the public sentiment that we are able to get based on these polls.
Let me take one now from the online audience about the question of the definition of the ROC. So Julian Koo, who I think you know, says, great presentation. As you say, international law arguably sees the question of Taiwan's legal status as unsettled since 1947, but how do we reconcile this view with the ROC Constitution, which does see Taiwan as part of ROC? Would you say that the 1991 amendments declare that Taiwan is part of a smaller ROC that consists only of Taiwan, the island, and a handful of islands? Is that how you're reading it? And then there's another question which I think is quite related. Notes that in the Constitution, Article 4, it says the territory of the Republic of China, in accordance with its inherent boundaries, may not be altered except by resolution of the National Assembly. So I think the question there is, there hasn't been such a vote, so how can we theorize that the ROC has actually shrunk to Taiwan and its nearby islands?
Thank you. Thank you, Julian, for the question. So, yes, that's indeed my claim that based on the constitutional order after 1991, the ROC, the current ROC, is already qualitatively different from that historical ROC established in 1912. So there's been discontinuity, as I emphasized in my presentation. That is to say, there's a breakaway from the old 1912 ROC Constitution, ROC, as the current ROC does not share the kind of visions that the 1912 ROC had. That is to say, the current ROC Constitution no longer sees the population in mainland China as Taiwan's population, as the current ROC's population. It no longer regards the mainland area as the territory over which the current ROC exercises jurisdiction. The government obviously has only been elected by the Taiwanese population, and Taiwanese population only, not including mainland Chinese. And on the international stage, the current ROC government does not seek to represent the Chinese state. It has always claimed to, since democratization, it has always claimed to represent the Taiwanese population only. So yes, that's indeed my claim. You can say that yes, the ROC has changed to a smaller ROC, but I would say the changes are so significant along the criteria of statehood that this is a new state since 1991. So the current ROC, despite still having the name ROC in its legal system, in the name of the country, it's not the historical ROC of 1912. It's a new country since the watershed moment of 1991. But having said that, there are sort of the baggage of the historical ROC still there in the current ROC Constitution. So the Article 4 is one example. Indeed, people argue that if you haven't changed your territory, then the territory supposedly is still the whole entire mainland China, plus Taiwan, Formosa and Pescadores after the war, which were, again, not transferred, but the ROC government anticipated them to be transferred after the war. So those are the things that we still need to reconcile, but I think those are not the practice that Taiwan is doing nowadays. I'm trying to maybe use the term substance and formality for now. If you look at the text of the Constitution, yes, on formality it says that the territory hasn't been changed. It hasn't been changed in the text of the Constitution, but in practice, has it been changed? Yes, I will argue that in Taiwan's constitutional practice, it's no longer considered, the mainland area is no longer considered part of the current ROC's territory. The ROC government not only cannot exercise sovereign power or jurisdiction over the territory of mainland China, it doesn't even pretend to be the sovereign power over the territory of mainland China. So the way I look at it objectively and subjectively. What is the objective constitutional practice and what is the subjective constitutional practice in Taiwan? And on both fronts, I would conclude that really I cannot find anything in Taiwan's constitutional practice that suggests that the Taiwan government thinks itself still owns the territory of the mainland area. I also don't think, subjectively speaking, the Taiwan government pretends or claims to exercise that power over the mainland area.
So you're saying, look at what we do, not at what our text of Constitution says.
Yes, yes. Thank you. Yes.
Okay. Yes, question in the back.
Yes, may I ask a question also about the 1992 things? In slide 6, you mentioned the historical ROC and the current ROC. There's a huge difference with the sovereign powers and everything. Because I don't study law, I study economics. So I have a very fundamental question. It's like, if you already states that, like, before 1992, both mainland and Taiwan have the sovereign power of Taiwan. Could you state that, like, after 1992, since we become a current ROC, so we can have the sovereign power by Taiwan only, but we don't need to achieve agreements with mainland?
Could you please repeat
so
the
before
question?
1992, the sovereign powers in your slides, it says it belongs to, like, Taiwan belongs to mainland China and Taiwan, both. But after 1992, it belongs to Taiwan only. And then the way you state that, because you distinguish ROC into historical and current one, and it's totally logical in Taiwan, I believe. But since you already mentioned before 1992, mainland China also plays a role in the sovereign power. Did you agree that, do we need to achieve agreements between two parties to state that, like, after 1992, Taiwan only belongs to Taiwan?
Okay.
Is there any agreements for that things?
I believe your question relates to how the dispute, the political dispute between Taiwan and China can be resolved. And yes, one of the channels, one of the mechanisms to resolve the dispute is to enter into political agreements to settle the dispute. To settle the dispute because China thinks that Taiwan is part of China and Taiwan doesn't think so. But that's very hard to, at this point, especially in this political environment where the PRC leaders have no interest in entering into negotiations with the DPP government, and the DPP government no way would give up its position that Taiwan is a distinct sovereign from China. So it's not possible, but under international law, I think that's the ideal solution, right? People sit down, both sides sit down peacefully to strike out a deal where that's acceptable to the two sides. But this is not possible.
So even in 1992, there's no agreements about that, like because I think the whole logic of the presentation based on your distinguishment between current ROC and historical ROC, if that is legit, everything's legit. But if that is not legit, like, you cannot, for example, this room, like this house belongs to both you and me, and you live in this house, and after that, after somebody came, like, after one moment, you said, okay, this house belongs to me, but since you have lived there for a very long time, but you don't need to get my agreement. It sounds like that for me, because I don't study law, so I'm not sure is it the case.
So you're right. There hasn't been any political agreement between the two sides over the issue of Taiwan status. It's not a territorial dispute, though. It's really a sovereignty dispute. But in any event, there hasn't been any political agreements, but that doesn't mean that the point that I discussed in the presentation doesn't stand, because the main point really is how Taiwan self-perceives itself the Taiwan self-perception in legal terms, that's crucial to the assessment by international scholars of Taiwan's identity. If Taiwan is perceived to be continue its identity as the 1912 ROC, then it's essentially saying that Taiwan concedes itself as part of China, and that China is represented by the PRC right now. So Taiwan is part of the PRC, and I want to break that cycle to say, no, that's not what Taiwan thinks of itself. In fact, Taiwan's constitutional order has been transformed, and this reflects the reality on the ground. In the past, under the authoritarian era, under Chiang Kai-shek and Jiang Jingguo, it was impossible for Taiwanese to express their political stance. So there's no way for Taiwan to be able to practice their the ideal constitutional order. But since democratization, it's become possible, and Taiwanese have done that, and that's my argument. So it really doesn't rely on the conclusion of the political agreements between the two sides. Yeah.
So we have a couple of, again, related questions about, and I think it's a nice segue from what you were just saying. You're making an argument about Taiwan's status that's grounded in a kind of choice of the Taiwanese people, or this is what I'm hearing. So one question is whether Taiwan has an inherent right to self-determination, so as a matter of law. And then relatedly, someone is pushing back at the idea that the Constitution the written Constitution might still say something, but that in practice, the government, the leadership might argue something different from what's in the Constitution. And that person asks, in a democratic society governed by rule of law, how can you not abide by what is actually in the Constitution? And therefore, Article 4, you need a vote of the National Assembly, which was democratically elected, in order to make that change. So, in other words, asking if there isn't an inherent contradiction in saying that this is the will of the people on the one hand, and on the other hand, not actually obtaining a vote that shows it's the will of the people. So two questions, inherent right to self-determination and how democratic is this really?
Okay, the first one, self-determination, it's been contentious, especially if one considers that Taiwan and China share a lot. Their people share a lot of similarities, and when we talk about the people in the context of self-determination, usually the first thing comes to mind is a different ethnicity that is that wants self-determination. But there has also been scholarship out there arguing that Taiwan's people, because of the decades of separation from mainland China, the Taiwanese people have formed their own political community that is different from that in China, and the people in the context of self-determination don't have to be a different ethnicity. You can, based on the political distinction, you can still be considered a distinct people that enjoy self-determination. And depending on what the view is on external self-determination and internal self-determination, then you can proceed, you can claim self-determination depending on whether you meet other requirements. So the people requirement is one of the many requirements, but I would say on that specific point, it's not unthinkable. Scholars have already argued that because Taiwan's politically separate from China, that people indeed exist in reality and should be able to exercise self-determination. That's the first point. The second is about Constitution. The text of the Constitution is very important, obviously, but I have to say, I want to give credit to my colleague, Professor Lin Jianzhi, who has written about this. The theory of the changes in the Constitution. So the Constitution is not always the same. It really the constitutionalism, the true spirit, I think, refers to abiding by the Constitution, but the constitutionalism also is reflected from the constitutional practice. So he uses, I think, quite clearly two categories to describe this. One is the capital C Constitution, the big C Constitution, where you look at the what's said in the Constitution. But then you also have small c Constitution, that is to say this constitutional order is not entirely based on the text of the Constitution, but being practiced and reflected in the practice. And so the idea is that constitutional changes are not limited to constitutional amendments, because the changes can be done by the country's own constitutional practice. So that's why I specifically use the term practice in my presentation. And I also want to draw the distinction between the formality and the substance. Another thing to say is that if we look at the practice of the ROC Constitution, say before 1991, say after 1949, the ROC Constitution back then in Taiwan pretended it exercise sovereign powers over mainland China. It pretended it had national assemblies from all provinces from China continuing to represent mainland Chinese people. Was this true? Simply because the constitution of the ROC back then said the ROC enjoyed sovereign power over mainland China? Is that the constitutional practice of the ROC then? No, because it's not reality. The ROC government cannot extend the sovereign powers over mainland China. So I do think that there are many instances where the text of the Constitution cannot be carried out, sometimes due to the circumstances, sometimes due to the sort of society consensus to carry out certain provisions. And I believe the situation that I was describing is that Taiwanese government, the leaders, all the Taiwan Constitution's constitutional institutions decide to not follow certain provisions in the text of the Constitution when they carry out their constitutional functions. And territory is one of them.
Maybe we could talk a bit about referendum, changing the Constitution by referendum, because it does have, there is a provision for that. And so far, as one of the questions asked, Taiwan has not used the referendum to address this relationship with China, and nor to decide to declare independence. Why hasn't it? How difficult would it be? Because I have read that it is actually, well, there's multiple requirements. You can tell us what the requirements are. And is the absence of a referendum an indication that Taiwanese don't necessarily support formal independence or declaration of independence?
There are many reasons why a referendum is not happening. So first of all, of course, is China's threat of force, and we know what will happen if Taiwan does intend to hold a referendum establishing, say, a Republic of Taiwan. And so it's risky and people know it. So referendum is not a feasible option. If you are risk averse, then you don't do referendum in Taiwan when you are confronted by China's threat. The second point is the legal threshold is very high, so it requires 3/4 of the legislative representatives to be present when approving the recommendation for referendum. 3/4 is super high for Taiwan's partisan environment. It's not even the KMT right now, which along with the TPP, the Taiwan People's Party, they together occupy the majority of the legislative yuan, but never would they be able to reach the point of 3/4. So no political party in Taiwan would be able to do that, would be able to reach that threshold. And then if it does get the approval from the legislative yuan, it has to be the constitutional amendment, the proposal has to be approved by the population, and that will require also a very high threshold. It's half of the eligible voters. So that's another impossible.
All
have
eligible voters, not
Yeah.
just those casting votes.
No, not just those casting votes. So those are two levels of mission impossible. So that's why we have a constitution that's not being amended since 2007. And then it's unlikely that there will be any amendments in the near future. So that's legally speaking. Threshold is high. Then you have the political risk. Then you also have, I would say, Taiwan's relations with China. As I say, there are still some remnants of the historical ROC elements in our constitution. Why don't you change it? I think one thing to take into account is there is still KMT support in Taiwan. Not all KMT supporters would support unification, but they support generally not provoking China, which is to say don't rock the boat, don't ruffle the feathers. So constitution amendment is kind of an off-limit topic, and that's because the KMT supporters usually do not want to upset the relations across the strait. So all these is to say that Taiwan is a democracy, and it's really normal to have different opinions in a democracy, that changes are hard to make. But changes are being made by the things that Taiwan does.
Sir.
Thank you for your wonderful presentation. And recently, Lai Qingde declared 17 strategies toward the mainland China. And is that because Trump's policy toward the Russia's invasion toward the Ukraine? I think maybe Taiwan is worrying about Trump might make some deal with Beijing over Taiwan. So in this critical moment, before Trump's unpredictable policy, the Taiwan government tried to show its determination of the government to both the Taiwan people and the international communities to defend Taiwan. Is that the reason? Okay, thank you.
Maybe in your answer, if you could first explain, and not everybody will know what those 17 measures are, right? So what are the 17 measures, and they're just proposals at this point, right, correct?
Yes.
Yeah.
Well, they are a plan. They are a plan by Lai Ching-te. Some of part of the plan can be carried out by the government without legislative approval. If you don't have to revise the legislation, then the government itself can implement the plan. But there are also parts of that plan that will have to that will require legislative changes, such as the implementation of the military trials. That's a big one. So that's something that will not be implemented immediately, but all the other things can. And so what are they? So basically the sense in Taiwan before Lai issued this plan was that Taiwan has not done enough. The Taiwan government has not done enough to counter the infiltration of Chinese influence in Taiwanese society. And there are also multiple cases of Chinese espionage, Taiwanese active duty servicemen, officers who are accused of spying for China. There's been a rise of such cases in recent years in Taiwan. So there's an increasing awareness that Chinese influence is serious in Taiwan, and Taiwan government has to do more. So that's basically that's the context of Lai Ching-te's issuing of that proposal, that plan. As to whether it has something to do with the Trump administration, we in Taiwan are watching what the Trump administration is doing every day. Really, it keeps political circles in Taiwan on their seat, on the edge of their seat. So, yes, we all know that it's very unpredictable, but we all understand that it's even more risky in face of an unpredictable U.S. government. So I don't think Lai Ching-te is trying to hedge its bet. The administration is not trying to hedge its bet, but the sense that the common sense and the consensus in Taiwan is that something's got to do. Something's got to be done to counter China's threat and influence and penetration of Taiwanese society. Hence, you have that 17 strategies. I would also add that because that was considered necessary, so after issuing the 17 measures, Lai's public approval really went up. And that just shows you how Taiwanese people are viewing the need to come up with a more comprehensive strategy dealing with China and be more, you can say, defensive, being able to really sort of toughen up against China, since China has been doing so much. That is the general sentiment in Taiwan.
So maybe there's enough time for another topic to be raised, which is the domestic political logjam in Taiwan right now. I don't think it's been very thoroughly reported here in the U.S. how severely the KMT and its ally, the TPP, the Taiwan People's Party, have been at odds with the party of President Lai, the Democratic Progressive Party, the DPP, and how thoroughly they have managed to sort of block each other so that President Lai is not able to implement his agenda through the legislature because everything that he proposes is rejected by the KMT and TPP, which have a narrow plurality there. And then the KMT and TPP take other measures that are challenged in the courts, although now they have more or less frozen the courts as well, or the Constitutional Court. They've cut the budget, they've cut spending of government departments, and quite seriously frozen a lot of government activity through either refusing to make appointments to bodies so that the bodies no longer have the power to act because they're missing the required number of people, or they lack budget. So this seems to be a serious challenge to democracy in Taiwan. Does it leave Taiwan more vulnerable then as it addresses this threat from China? And what are the ways that that vulnerability could be addressed, perhaps, or countered? Are the parties so caught up in their own agendas that they can't see the larger need to come together in some way to reconcile their differences? Is there a strategy here that we can't see from a distance?
This is a tough one. So you've very well summarized the situation. The blockage by the legislature on many levels, including the Constitutional Court, is not being able to take in cases because it just the legislature haven't approved the nominations by President Lai for the vacancies that have been left in the Constitutional Court, and then also the legislature approved legislation requiring the Constitution Court to have a certain threshold before it can be in session. So that is to say, by way of legislation, the legislature indeed paralyzed one important constitutional institution in Taiwan, the crucial one. So whether this is unconstitutional, that is in dispute, and this case can be really watershed moment in Taiwan's constitutional jurisprudence. So we will be watching closely on that one. Coming back to your question, this is indeed making Taiwan very vulnerable. Just take the defense budget as an example. The legislature can easily cut or freeze certain defense budget that Taiwan is urgently in need, and it will also undermine Taiwan's the trust with Taiwan's determination to defend itself. So if the U.S. government cannot carry out the arms sales to Taiwan because of the defense budget issue, then of course it undermines the relationship between the U.S. and Taiwan. So the vulnerability is really on multiple fronts. And that's just the most immediate consequences, but not to mention the undermining of Taiwan's democratic institutions. And so this reminds me of the 8 period of Chen Shui-bian's presidency from 2000 to 2008, when the legislature was dominated by the KMT back then, which also boycotted a lot of bills and budget, so that Chen Shui-bian was turned into what we call a lame duck president, who was not able to carry out a lot of the policy that will require legislature approval. So I worry about Taiwan's situation for the next 7 years. Lai Ching-te has been in office since last May. He may have a second term. And if he does, if this sort of standoff continues, will he become another Chen Shui-bian? Yeah. But the strategy, coming to the strategy point, right now I don't think the DPP or the KMT have any appetite for compromise or reconciliation. The strategy right now by the DPP is to try to recall as many legislative representatives of the KMT in order to not have KMT continue to dominate the legislature. So it's a very confrontational approach. The KMT is also very confrontational. This is a very fierce, partisan environment, and nobody seems to want to make a concession.
Okay, so let me just ask, Professor Cohen, do you want to make a quick final remark before we wrap up our session?
I think this has been a wonderful presentation. We ought to do this every 3 months. Get Yu-Jie to come back. It's balanced, informative, and crucial to our security. I congratulate you, Catherine, on this whole series of programs. Nothing could be more important.
Thank you very much for joining us, and thank you all who have been with us here in person and on the live Zoom. We'll see you for the next installment in the series, which will be in about a month. Thank you.
Thank you.